Hi, I'm Dr. Max Wachtel, forensic psychologist, and this is 3-Minute Explanation, my attempt to explain a complicated subject in 3 minutes or less. Today's topic, competency to stand trial. Our understanding of competency in the United States is based on Dusky versus the U.S. It's a 1960 decision by the Supreme Court. Now, Milton Dusky, a 33-year-old man, was charged with assisting in the kidnapping and rape of a woman. He was diagnosed with schizophrenia, and he was found competent after a brief mental status examination. He was convicted and sentenced to 45 years in prison. His attorney had some problems with that competency evaluation and escalated this case to the Supreme Court. The court agreed that a brief mental status examination isn't sufficient to establish competency, so they remanded the case back to the trial court. In Dusky's case, his sentence was reduced to about 20 years after it was remanded. Now, how did this affect the United States going forward? Well, we have what is called the federal Dusky standard, the definition of competence or incompetence. Prong number 1, a person has to have a sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding. There is a present ability component. It has to be in the present. If a person was incompetent in the past, it doesn't necessarily mean they're incompetent in the present. And it has to be rational. The person can't just do whatever his or her lawyer says for irrational reasons. Prong number 2, the person has to have a rational as well as factual understanding of the proceedings against him. And the factual basis, does the person understand the key players in the courtroom? Do they have a good idea of how court procedure works? And are they able to use those facts to have a rational understanding of what's going on and to be able to make rational decisions? They don't have to be good decisions, but they have to be rational decisions. Those are the 2 prongs, and that is what criminal competency is. Now, states have different definitions for competency to stand trial. That Dusky standard is federal, and states mostly go by Dusky or pretty close. Competency is not a legal defense. You can't plead incompetence. Restoration to competency treatment occurs after a person has been found to be incompetent, and it usually involves a combination of legal education, psychotherapy, and medication. A person is able to be forcibly medicated if he's refusing to take medications, if it's for purposes of restoration to competency. That's a huge issue, but it is possible. And then after restoration, the person faces his or her charges. Most people are restorable, and like I said, this is not a legal defense. It's just a timeout until restoration occurs. Now, why is competency important? Well, in the United States, we have the right to assistance of counsel, to remain silent, to due process, to a fair trial, to testify or not on our own behalf, to confront our accusers and cross-examine witnesses. We have all these rights, and if we are not competent, we can't exercise those rights competently, and that is a problem in the U.S. That's it. That's my 3-minute explanation. I've gone over a little bit, but I hope that you have learned something fairly quickly.